my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah. Enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana. Yeah. Uya matinyana. Uya matinyana. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William Miguel, come here. 1, 2, 3. Hello, lovely people, wonderful family out there. Good afternoon and welcome to another edition of the Community and the Law. We're bringing you this edition that will, as usual, get us into delving into the realms of law, and we're doing that courtesy BWF solicitors. Now, when we come on the Community and the Law, we have your questions, we have your issues and concerns, then we address them. Apart from that, we pick up one particular issue that bothers the community during the week, and we get the lawyers to address that. My name is Oriku Usifrimpon, and today the question is, if we consider EUSS family application, the question we are looking at mainly to address is my sponsor's partner, a dependent parent. We'll be looking at that and some of the technical issues that you need to know and how we can get them addressed. All in all, let's jump into the community and the law together. Yes, you realize the time people are picking up their phones and are sharing the links. This is the community and the law. Another one for you this Saturday afternoon, and I'm privileged to be in the hot seat, going to direct affairs and mediate the discussion. And the question we're asking this afternoon
is when it is that you have your EUSS application to complete. Your sponsor's partner, can you describe him or her as a dependent parent? The answer may obviously be yes or no, but if it is yes, what are the reasons? If it is no, what are the reasons? Technically, what's going to happen? We have the privilege of going to the realms of the law, and by courtesy of BWF solicitors, we will be bringing you that discussion. BWF solicitors, let me talk about them briefly. This is a law firm that has been operating here in the UK, and especially in London, for more than 30 years. The senior partner, Uncle Ben, has practiced for 30 solid years and is still going strong. Now, BWF Solicitors picks up everything the law demands that you know and explains that to you or brings it to your doorstep so you are comfortable with that when it comes to divorce, when it comes to family applications, when it comes to naturalization, when it comes to nationality, your stay here in the UK, how you can make any application for it to be very successful, you go to BWF Solicitors. Now, BWF Solicitors also does the wills and probates. That's the question. That's the word. Wills and probates. And when they pick that one up, they take you through the counseling aspect of the whole thing, so you know that it is not something you should be scared or afraid of. Then again, they also help you go through the application and get it right. So go to BWF Solicitors. They are at 214 to 218 on the Tottenham High Road, North London. The postcode is N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. When you want to go to them, weekends is just by appointments only. So make sure you do that. And the telephone number you need to call them and book an appointment is 0208 493 7340. I say the number again, 0208 493 7340 or 077 127 61884. I take that again, 077 127 61884. BWF Solicitors, they are trusted partners when it comes to the law. And I think this message will drum it down home.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, thank you very much, BW Solicitors. Well, you see what I'm doing on my phone? I just want you to do the same. I'm picking up the link and I'm sharing with my people in my network. So when you are on here, two things I need you to do: pick up the page, share, and like, and also put your comments in the comment section so we can all do that together. We're live on BWTV. We're also live on BWF Solicitors Facebook page and BWF Solicitors YouTube page. Um, those of you who are here, I can see my sister Tilly Duma live here, welcoming people. Lovely family, she says. Thank you very much, Tilly. Thank you for coming on. Ezekiel Johnson, welcome family. Keep sharing. That's the message and that's the view. Chi Wo, welcome on board, everyone. Chi Wo, thank you very much. Let's hear from you as well. Demonukum says good afternoon to all of you. Those of you on there, if you come up and you sign on, let me know on the comment section that you are around and I'll acknowledge you. And also when you have any question or comment, please pick it up and put it on the comment section. You can also text us on 079504222780. We have Emmanuel Sechi watching us live on YouTube. Good evening, Riku and Lawyer Charles. Yes, Lawyer Charles will be making an appearance pretty soon when I've done my nuggets and announcements. I'll be introducing him. Tilly says again, Nanaji, my senior minister, Brawa, and a class is going on. That's an invitation to Nanaji, and the class prefect to come on board because the class has started. Yes, it's a forum for us to all have the discussion, but it serves as a classroom as well because people who have knowledge of what it is that we are discussing put their comments on there and people learn. So we find that very interactive and very interesting. So when we call that the classroom, that's the reason. Ivano Sechi, your next comment, let me pick that one up quickly. Happy Mother's Day to all our women. Yame Inshra Emma. God bless women. It's Mother's Day tomorrow, the 19th of March 2023. And Emmanuel has taken the lead, wishing all our mothers happy Mother's Day. James Watlema, good evening. Hello, James. Thank you very much for coming on board. Now, one very quick announcement I want to put across is that Easter Monday, there's something coming up on BWF Solicitors platform, and that we will be getting you to enjoy barbecue and a legal session. So just keep that date open. On the 10th of April, I will be coming your way with something so special live from one of the venues here in London. So those of you in London and of course all over UK, I will be bringing you that detail very soon. But I just want to drop the hint that on the 10th of April 2023, there will be a barbecue. And of course, there will be some legal matters as well. There will be a legal clinic. The flyers and other things will come later on. So just keep an eye on that and watch this space. Now, before I bring in a lawyer, let me also remind you that the whole month of March, we celebrating Ghana. And get your knowledge of Ghana so polished that that may win you something, you know. When I get into my good elements, I will bring you something. So get your knowledge of Ghana so well polished and watch this space as well. Now let's pick the nugget that I have for you. Ladies and gentlemen, we're talking about intestacy. That it's a situation that occurs when a person dies without leaving a valid will and is said to die intestate as opposed to testate. The order of priority on interstate is set out in Section 46 of the Administration of Estates Act 1925, AEA 1925, as amended. Where there is no surviving spouse, the children of the deceased receive the estate. This includes legitimate, illegitimate, or legitimated children, as well as children adopted by the deceased. Even if the deceased made a will, there are circumstances when some of the estate may fall into intestacy. Dependents who do not benefit from the intestacy rules may make an application under the Inheritance Provision for Family Independence Act 1975 for maintenance. This one is quoted from Miles and Shearer versus Shearer 2021 case, and the respondent Elot versus the Blue Cross and others, that is the appellant. So intestacy is when a person dies without leaving a valid will and is said to die intestate as opposed to an intestate. The order of priority on intestacy is set out in Section 46 of the Administration of Estates Act 1925 as amended. Where there is, that's where my interest is, and I'll be asking lawyer to really pick those bits and explain them to us. Where there is no surviving spouse, the children of the deceased receive the estate. This includes legitimate, illegitimate, or legitimated children. I think there must be some differences. Legitimate, yes, we can decipher that. Illegitimate, yes, we can. But legitimated children, what does that mean? Lawyer will be telling us. And we also will be looking at children adopted by the deceased. That's also a bit straightforward. Even if the deceased made a will, there are circumstances when some of the estate may fall into intestacy. And which part of the estate are we talking about here? Lawyer will be explaining that. And dependents who do not benefit from the intestacy rules may make an application under the Inheritance Provision for Family Independence Act of 1975 for maintenance. So we'll be unpicking these very briefly, and when lawyer is explaining that, he will pick those ones up again. But before then, let me also once again say that if you want to really write the English language, prepare very well and make sure you pass very well once and for all, then you would be working with KT Education Consult. They help you prepare for your IELTS, B1, B2 for skilled worker route, visa routes, all the visa routes really that require you to write your English language. Please talk to KT Education Consult. They are on 07596 620 154. If you're outside of the UK, you start with 0044 7596 620 154. You can send them a WhatsApp message and they will get back to you and arrange for you to join their classes so you can pass and pass very well. They are asking you to prepare with experts and pass with ease. Or you can send them an email to ktedconsult@gmail.com, kt.edconsult@gmail.com. Remember number again, 07596 620 154, 07596 620 154. And you have the situation where you have to apply for any type of visa, visitors, where are the work permits, parental route, and all those bits that you have to apply for your visas. How to make that successful is to consult and contact the BWF solicitors. Now they tell you you can have a visitor's visa application done so successfully through them by calling them now on 0208 493 7340 or the emergency number 077 127 61884, or in Ghana 050 462 2794, 050 462 2794. I have somebody who sent me a text that you were calling, a number wasn't going through. You know what? Send a WhatsApp message to the emergency number. That is also okay for us to get in touch with you, or get in touch with BWF solicitors, so to speak, at 0044 77 127 61884, 077 127 61884. BWF solicitors, they are our trusted partners when it comes to the law. Let's take their message again.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner. This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, yes, we had that short break there. Thank you very much for sticking around. I can see so many people sharing and passing comments. Tilly, thank you for that wonderful job you're doing over there. And also to Ezekiel Johnson on the other part. Please kindly share. That's what Tilly is telling us, and that's what I'm acknowledging that. Kweku, I was expecting you to put on traditional wear or kente as we celebrate Amagana. Yes, I've got my traditional bit here. So, Alex, I wasn't out of place. So, as I said, sharpen your knowledge on Ghana, and I will be probably giving you something to celebrate. Rebecca, today is your birthday. Becky, yes, happy birthday to you. You are March born as well. That's wonderful. Thank you very much for letting us know. Happy birthday. We share your day, we share the blessings, and we ask God to continue to bless you all throughout, and whatever it is you have on your mind and in your heart. May the Lord get it done for you. Good afternoon to everyone. Sarah Pizzo saying that. And Tilly, yes, keep doing that for us. Thank you so very much. Um, well, people are sharing. I think I fall into some networks and I've seen that the share is coming my way. That's so very wonderful. Thank you so very much. Let's see who we have here. Now, I want to remind you again that the um barbecue will be coming off on the 10th of April. That is Easter Monday. And I would want to invite you to come join us. We will be having that barbecue, then a legal clinic, and it's going to come off, as I said, from 12 noon on Monday, the 10th of April, 2023. And it will be happening at the ICGC King's Temple, ICGC King's Temple, Frederick Bremer School, Siddeley Road in Walthamstow. That is London E17 4EY, London E17 4EY. As I said, I will be dropping the flyer very soon. That will help you to share with others in your network and also to make sure that we all come to enjoy very soon. So make sure you are with us, and when you have the flyer, please share with your people in your network. Barbecue coming up on the uh, 10th of April 2023 at the Frederick Bremer School, Siddeley Road, Walthamstow, London E17 4EY. Now, on that day, we'll be having, as usual, the barbecue, the church premises. We will have our lawyers around who will be having a legal clinic. And if you have any concern, any question in the law, just come over and have some free legal consultation. So remember, it's the 10th of April 2023 from 12 noon. The last time we went there, I was playing football. We had some nice bits to eat and a lot to drink. And also, we had our lawyers giving some free legal consultations. So remember, we're doing that again, and it's on the 10th of April 2023. Free legal consultation, barbecue, and it's on Easter Monday. So remember to come with us. And I want to give you the address again. It's ICGC King's Temple, Frederick Bremer School, Siddeley Road, Walthamstow, London E17 4EY. Now, if you want any further detail of this one, you can call the emergency number 077 or the main BWF solicitors number, that is 0208 4937340. So remember that we're having the barbecue on the 10th of April 2023. Now, let me pick up the nugget again, and then I'll get lawyer to help us digest that. Intestacy, what is that? Now, the information we have says it occurs when a person dies without leaving a valid will and is said to die intestate or as opposed to testate. So, lawyer, get ready. I'm getting, I'm getting you to explain that. Very technical. The order of priority on intestacy is set out in Section 46 of the Administration of Estates Act 1925. Now, the further explanation here is this. Where there's no surviving spouse, the children of the deceased receive the estate. This includes legitimate children, illegitimate children, or legitimated children. What's the difference? Well, we're also looking at children adopted by the deceased. So even if the deceased made a will, there are circumstances when some of the estate may fall into intestacy. Dependents who do not benefit from intestacy rules may make an application under the Inheritance Act of 1975 for maintenance. And with that, let me go back to the main board, and I have lawyer Charles Asma from BWF Solicitors. Fantinya Washe Fugu. Lawyer, good afternoon.
Good afternoon, Rakoko.
Well, I was sorting out a few technical things, so I hesitated in bringing you on, but now everything is fine. Viewers, don't worry, he's here. Lawyer, I've invited people to the barbecue, which excites me so very much. I've spent so much time on that. But this week, there was mention of writing a will. People are not too comfortable doing that. But there's a situation that would prompt people to write a will. When somebody dies without writing a will, and what happens behind the person sometimes is not pleasant. Sometimes it brings in a lot of confusing situations and the rest of it. I approached you and you gave me this intestacy or testate. What is that? Is it too technical? Is it something we can just break down for people to really grasp and understand?
Thank you very much, Rakoko, and a very good afternoon to viewers and listeners. So our nugget today is a build-up to one of the services that BWS offers the community, and it's been on the shelf, but we brought it out again, and that's will writing or drafting and probate services. Now, why are we talking about will? We know that will is just an expression of the deceased person's intent whilst alive.
Okay.
And therefore, that intent ought to be implemented to show that, one, we honor the dead, and at the same time, we're not doing anything contrary to what the person would have done if they were to be alive.
So that is like carrying out his wishes when the person is
So
dead.
the wish or the will, so that's the word, the wish or the will of the dead person. Now, the good thing about the will is that it sets out everything, and therefore we carry it out. Things are clearer, easier, smoother. Now, if the person has not expressed any intent or wish, then it is up to the state to effect that. So when a person has a will or has already expressed intent before death, we say the person has died testate. So there is testament of their intent.
So it means that when a person writes a will before he dies and he passes on, once the will is identified, found out, and we'll get into how it's executed and all that. If that happens, then the person died testate.
Yes.
The opposite?
Intestate.
Intestate.
So the person dies intestate. What we are saying that the person did not officially express intent before death. And when we say officially express, on paper. And by today, we are not going to discuss will and what, because a lot of that will come up as part of the services that we offering, but today let's just home in on this. So if you wrote a will or made a will before you died, how you wanted your properties to be shared is what is effected. If you did not, then the state, by operation of law, will decide how that is effected. So from the nugget today, again, we have the case law and the pinning, and we have also the law that looks at the administration of estate. So we're looking at Administration of Estate Act 1925, and especially with respect to Section 46. So we have the surviving spouse. So we have the surviving spouse taking preeminent over anybody else. We have children, and children here, we're looking at the children of the dead person.
Okay.
And here, so whether they are stepchildren or not, children of the deceased. That's why the nugget specifically say children of the
The
deceased.
deceased. Okay.
Then-
Now, there are some technical bits in there. When you say where there is no surviving spouse, the children of the deceased receive the estate. I explained children. Now, it goes on to outline who the category of children. We have legitimate children, illegitimate children, or legitimated children. Is that different?
So you can see that if something is legitimated, it means it has been made legitimate. But the point we are making with respect to that is that we have children who are obvious children. If we say legitimate children, we know that sometimes we do use certain words to describe how people were brought into the world, or some children are given birth to. Now, if the child is legitimate, we know that we can identify the parents, we can identify the father, we can identify the mother in that respect. Let me put it simply. If we can't identify the parentage of that child, so to speak, sometimes we use that loose word. This child is illegitimate. So nobody can place ownership, so to speak, on that child.
Okay.
And if you are not legitimate, then you cannot have access to the estate of the father who is passed on or the mother who is passed on in question. Now, so where there's contention of that illegitimate child or legitimacy of that child, and that contention is resolved, then the presumption will be that there has been that child or that who was illegitimate has now, by operation of law through other process, has become
legitimated.
legitimate,
Okay.
has been legitimated. So it can be that there's contention over actually whether the child is a child of this person or that. They will go through DNA process.
Okay.
Then it is confirmed, or the process points out that, oh, okay, so this is part of the children of this particular person. Then, so it's a case of semantics.
Okay.
But simply
So-
illegitimate, legitimate, and those that can be made legitimate.
Can stepchildren be legitimated to become children of the deceased?
Right. So so you have your stepchildren, but technically we are looking at the line
Okay.
of succession, for example, but let's say line of inheritance. If you are looking at your children and the person did not, for example, make a will, can we include the stepchildren of that person? Technically, it may not be, unless possibly we stretch the argument and we follow through other aspects of law to see that based on all that we see, can these children be considered children of this person? So in terms of whether we saying that they can be legitimated or not, I mean, when it comes to stepchildren, their line of inclusion is obviously different. So we will not go deeper into the stepchildren argument. I think for today, the key understanding is that it's good for us to write a will before we pass on. The consequence is that if we don't, then the state, through its own processes, will distribute your properties for you.
For purposes of time and our discussion, I would want to find out, there is a caveat here that says that even if the deceased made a will, there are circumstances where some of the estate may fall into intestacy. Why would that happen?
Okay, so the will So the deceased person would have said or expressed how his properties or her property could be either way should be distributed.
Right.
Now, where it's not clear
Okay.
which is which, then we cannot include that in the will or to be the intent of that person. It might even be the case that the person did not even remember to include that particular property or estate into his wishes
Okay.
or the will. So any a property that falls outside the list of the list included in the will, then we can say, well, the person did not make a will for that.
Okay, then that would
Then
fall under
then the
intestate.
presumption is that the person that the will does not cover. If the will doesn't cover it, then it falls under intestacy.
Okay. And under what circumstance would, like the last paragraph, dependents who do not benefit from the intestacy rules may make an application under the inheritance for maintenance?
So the person may might have had dependents or people who depend on. They could be orphans that he was taking care of, or stepchildren he was taking care of, or anybody, so to speak. And it could, remember we talked about spouse. What if the person is not a spouse? And who is the spouse? So if we straight the argument, we say, well, the person dependent on the deceased, but there's no provision in the will. But the person must survive.
Yeah.
And the person will make application so that in terms of administration of the deceased person's estate, their maintenance, the maintenance of those dependents could be factored into.
Okay. All right. Whatever it is, I would want to. It's a difficult subject for certain people, but I would want to bring it down, water it down so very well to say that it is necessary you did it. It is easier to get experts like BWF solicitors to help you do that. Sometimes it's difficult for you to make up your mind. You might want to go through some counseling and the rest of it. Talk to the experts and they will help you do that. Don't leave it too late. Don't leave it till when you become so incapacitated to do it, and it might create problems for your survivors. I know one day we will have a whole session to treat the aspect of a will, how it is done, what to do, what not to do, and where to go when you need help. BWF Solicitors is ready to help us every time, every day, anytime. Intestacy occurs when a person dies without leaving a valid will, and I don't think you would want to have that situation, and does that get your children or survivors go into that. So write one, talk to BWF Solicitors, 0208 493 7340. And that brings us to our topic for today. Very interesting one. Now, the EUSS scheme has a lot of things around it that we haven't really unraveled very well. Your sponsor. Who is your sponsor? Your sponsor's spouse. Is your sponsor's spouse qualified to be your dependent parent? The EUSS family permit application. What are the things you need to know about it? Now, listen, this is a forum for you to have all these questions answered. So I would want to ask you to ask somebody who hasn't joined us to join us and pick up the link, share, comment, and send your questions in. The text number, as I have said already, and I want to repeat, is 07950 422 780. 07950 422 780. Or when the lines are active, you can call us on 0208 123 1016 and or 07399 208 468. Lawyer Charles Asma, why is it that we have so many things about EUSS? I thought it was a simple and a straightforward something.
Well, remember the whole discussion about Brexit could have been straightforward, but you and I know that it's still not straightforward. But we haven't even finished dealing with what happens to Northern Ireland what happens to this, the Good Friday Agreement and all these things are still lingering on. And therefore, much as it appears or seems straightforward, it's not straightforward. And if the whole concept itself is not straightforward, then any remnant of it will not be straightforward. And that is why applications under the provisions of Appendix EU will never be straightforward. Even there's case law ruling that if the person came here and decided to say, I don't care about EU settlement scheme, so I won't do it, the law says, well, they are okay.
You can't deny the person
deny
that
them,
right.
so don't mind it. So you can see the whole program or project is not straightforward. So today we are looking at dependency and who qualifies to be your dependent parent.
Right.
And whether such dependent parent is the substantive sponsor or the spouse of the substantive sponsor. And what if the substantive sponsor is not able to show that you depend on them? Can the spouse be able to do that and cover you in that respect? So these are the discussions we are having this afternoon. Now, we know that if you're already in the UK, you make application under the EUSS scheme or the EU settlement scheme for you to be given pre or settled status, as we know, either under EU11 or under EU14 in terms of the paragraphs. Now, what if you are abroad?
Right.
What do you get? If you are abroad, of course, you make your application for entry clearance and you show either you are making an application based on your parent and whether it's based, if it's based on your parent, whether you need to show dependency or not.
Oh, no. Yeah.
Whether it's based on your child, and if it is so, whether you have to show dependency or not. Now, this conversation, you can see that we are looking at focusing more on children who are making the application based on their parents,
right.
and saying that they depend on their parent, and therefore that dependent parent suffices to sponsor that application. I refer you to the whole provision, Appendix EU provision to the immigration rules. And I take you down to one of the definitions, Annex 1. So the Annex 1 looks at the key definitions. And therefore the courts and the caseworkers will look at what does the law define this, or how does it define that.
Okay.
So if one of them is a dependent parent, and it says that dependent parent is the substantive or the relevant EU national sponsoring the application or their spouse.
Okay.
So it might be that you are not the main person sponsoring the application, but you are the spouse of the person sponsoring the application.
Okay.
So the question is, are you covered within that definition? And the law, the provision says yes, because it says or, and anytime we make reference to or, we say that we are looking at this or that. So you have a choice.
Okay.
If the main doesn't work, go for the substitute.
Has it always been so, or there have been an amendment to the regulation of the law?
It is what it is. The EU provision as structured or drafted is what it is. So that one gives a range of definitions, including what dependency is. But our focus today is who is a dependent parent. Can A or B be my dependent parent? And that is it's important because there are instances where the sponsor may not be able to prove that the child depends on them.
Okay.
For whatever reason. However, the spouse of the sponsor can prove that the child depends on them, and especially children who might be stepchildren.
No, but when somebody says that I'm sponsoring somebody and has agreed to do that, if the person is not able to prove it, then he or she doesn't even qualify to be a sponsor.
Well, people change their minds, and therefore it might be that at the time they sponsored the application, they were in good spirit, and subsequently something happened, and now upon grant of that leave to enter, and having entered the UK, there has been change in family circumstance, And therefore, even though presumption is that this person sponsored the application, that change in circumstance might suggest that the person cannot continue to show that the child or the stepchild depend on them.
Okay.
And if you can't prove later that they continue to depend on you, can I then move to the other side, the or, to say whether I can prove that the spouse can prove that the child depend on him or her.
Okay.
If the spouse can prove, then we set aside the main sponsor, even though the main sponsor is equally relevant, but we are applying the law. And the law says that this or that, it means either of them.
Oh, mhm.
So if this or that, then if this doesn't work, then this
That
must
should
work. And they can't say, well, it should be the sponsor and not the spouse. But the law says all.
Can the two be put together? For instance, if you proving that the person depends on you, you support him or her financially, can I add the evidence from the other side, my partner, to what I have? So, for instance, if I send 1,000 CDs, 1,000 naira, or £100 every month, and my partner also supports it independently or through her own means to support with another £100, could we put the two together as evidence to make it strong?
Yes, often that's what happens. But one of you, the relevant EU national can also sponsor if the spouse is not able to support the application.
Right.
So the focus is the relevant EU national.
National. Okay.
Then we move to dependency. And dependency under Annex 1 is defined as relying on that sponsor or the sponsor's wife to meet your daily needs or essential living needs.
Okay.
And this includes financial needs, emotional needs, psychological needs, physiological needs, and any other need, so to speak. So if the person depends on the spouse of the relevant EU national for guidance and counseling in terms of career choices, in terms of other choices, that's dependency. If the person relies on one of them to meet their emotional needs, phone calling them, speaking to them, finding out, to make them feel, then that's also dependency. So we are not just looking at financial dependency.
Okay.
That is one aspect.
And I guess that's one of the things that people take for granted, that if we're talking about dependence, we're talking about financial dependence rather than it encompassing all the other bits you are referring to now.
Because we think that help is all about food, but help goes beyond food.
Obviously.
And therefore, if people are helping us to have what to eat, if people are helping us to have where to sleep, if people are helping us to feel more or less to enhance our general well-being, then all this put together constitute dependency. That means without that person, we cannot survive
Okay.
materially, emotionally, and even spiritually. So the question here is, who is the main person here in terms of parent?
Just right. Yeah.
And the law says that a parent is the person sponsoring or the EU national
Supporting
or the wife
the wife.
or husband.
Okay.
So let's take a classic example.
Right.
If somebody's application was sponsored by their stepmother or stepfather to enter the UK under Appendix EU entry clearance, EUSS family permit, they've been given 6 months, for example, they've entered the UK. They have to make further application for pre-settled or settled, depending on their age, whether 21 or above 21 or below. Then, as you said, but if at the time of application, the person made certain representations that they are happy and they are supporting the application, why can't they continue to show so or do so? And I said that, well, things happen every day in life.
People change their
And
minds.
therefore, we should have that expectation that life is uncertain. And if life is uncertain, and at this point, the main person cannot show that the child continues to depend on them. If they are living together with their spouses and they jointly sponsor the application, or even if they didn't jointly sponsor the application on paper, but everything points to the fact that one contribute and therefore the other was able to sponsor the application, then the child can say that, right, my main sponsor, for whatever reason, is not able to show that they continue to help me to meet my needs.
That's right.
However, their spouse is able to show, and their spouse here I'm talking about, for example, my father or my mother, because I'm the stepchild to the main person. And for whatever reason, it's not possible for them to show that I continue to depend on them. But the spouse is able to show that I continue to depend on them. Can we rely on the law? Yes. Because the definition of dependent parent is the main person sponsoring the application or their spouse. So if their spouse is my father, biological father, and the main person, the relevant EU national or EU national is my step parent, and for whatever reason, my step parent has had a change of spirit or heart and is not able to prove that I depend on her or him, but my biological parent, being the spouse of this person, is able to show, can I rely on the dependency of my biological parent, even though he didn't sponsor my application? The answer is yes, because he or she qualifies to be a dependent parent.
Okay. We over the past few weeks, we have discussed certain situations where partners would have separated. Um, in a situation like that, when my sponsor is still legally married to the partner, but they are separated, could I still depend on both of them maybe to support my application? I'm asking this because we're saying one of them could to do that, and they may not be living together. If they are separated, does that still get me the opportunity to get the other one supporting?
So, I would say that, okay, so let's start from the point of application. So before the person entered the UK, they showed through the application that the sponsor meets their needs. Therefore, they depend on the sponsor and they have proven the dependency by way of financial dependency, money, the remittances and all that, including accommodation, the rent. They've also proven emotional dependency by way of WhatsApp communications. They've also shown other aspects of physical dependency by way of going to visit them.
Okay.
So they've shown that they travel to visit and all that. Okay. Now, let's assume that the other spouse did not support this dependency calculation with anything. But the main person sponsoring the application did. The person has entered the UK, because has met the criteria, entered the UK. And for whatever reason, you talked about separation. There has been a separation just after the application, for example.
Yeah.
And upon entering the UK, the separation has become obvious. So it might be that they are not even living together. Or they are living together, but things are not what ought to be. And the person is not willing to support or sponsor the application at this stage.
Right.
Can the spouse step in? That's the conversation.
Yeah.
Because the law says show dependency. So when you are making the application, you don't have to prove relationship because you've proven relationship
Already.
So you have the relationship proven.
Okay.
How do you prove it? I am the child of my biological father or mother, and my biological mother or father is married to the EU national, and therefore I am a family member of the EU national.
Okay.
You've proven your relationship. You prove your dependency as well, especially if you are 21 and above. You prove your dependency as well.
Yeah.
How do I prove it? now we know things are not what ought to be and what used to be.
You used to be.
So, but I'm here. I'm living with my parents, but one of them, for whatever reason, is not showing much interest in my welfare, for example. But the question is, are you still depending on that dependent parent?
Okay.
So we have to define who a dependent parent is.
Okay.
And the law says that a dependent parent is the sponsor or the sponsor's wife.
Okay.
So they are telling you, the child, that your dependent parent is your stepmother or stepfather who sponsored you, or your biological mother or father who is in that marriage, based on which you became a family member.
Yeah. So by dint of that relationship, whether as your biological or a step parent, that relationship qualifies that either of them could support you. One could start and one could continue, or vice versa.
So yeah, but the point we are making is not that one will start and go, but the nutshell is that when they were making the application, they might have done it jointly, or one might have fronted it, the other one supporting it invariably.
Yeah.
Because if they are living together, then one will buy food and they all share, so that the other one could support the care of their stepchildren at home.
Okay.
So there's contribution. So the law recognizes the fact that the spouse of the relevant EEA national is equally a dependent parent. Because if the person is not in the picture, maybe the sponsor alone could not have been able to meet
sponsor
the
fully.
needs of those children. Now, if the sponsor is not in the picture, and the burden is now on the biological parents, what can the children say in terms of dependency? The children can still say that we depend, or I depend on the spouse of my sponsor, and therefore I still have my dependent parent.
I'm envisaging an interesting scenario here. You might have mentioned it, that my sponsor is an EU national. Now, when the application was put through, my sponsor did not have that partner. I'm going for the extra bit, and my sponsor's partner has not come into the picture that has the wherewithal to be able to sponsor me or even support me. The person that was not in the picture at the beginning has come along the line. Can we still use that as my sponsor's partner being a dependent parent?
I think we are addressing the same point.
Okay.
Because give and take, they were living, they are parents of that child.
At the time of the application.
And presumably after the application. Save for the fact that there has been misunderstanding, and therefore the sponsor may not be able to show that dependency. If we pointed out the last time that the fact that there's separation doesn't mean there is no marriage. And therefore, until divorce, there is marriage. And so the law recognizes that it's weak, but not completely out. Now, we are talking about two things, the relationship aspect and the dependency aspect.
Yeah.
So the focus is, okay, you've been able to prove your relationship because the marriage is still there. But even if your main sponsor was there, you could still not be able to prove dependency if you came and they are not looking or taking care of you. So if they are there and they are not taking care of you, you cannot prove dependency. And if they are not there, and of course they are not taking care of you, obviously you cannot prove dependency. But the question here is, are they together? I mean, are they two? Of course they are. The main sponsor and the spouse.
The spouse.
And the focus is on the spouse. And the question is the spouse of my sponsor a dependent parent? And the next one says it includes spouse of the sponsor. And if you include the spouse of the sponsor, whether they were part of it or they were not part of it, they are dependent parent.
Okay.
So our argument is, when do they bring their evidence to confirm that they are dependent parent?
That was going to be, when do they come in? How do they come in? And what do they need to do?
So, at the time of application, we have said that they can do it jointly. But if the application is successful, then we know that every box is ticked. That's why the application is successful.
Okay.
So we are not worried about dependency. We are not worried about relationship. Now, the person has entered the UK with the entry clearance. They have to proceed to do the pre-settled status application or settled, depending on the age
Right.
of the child. Now, reality setting. The main sponsor is not willing or is not able. Let's put it that way. Because as I said, if they did it, why are they not willing? If they did it and this time they are not able to prove dependency, could be that they are not working,
Okay.
they are unemployed, and therefore they don't have income. So they themselves depend on a spouse.
The spouse, yeah.
So if they depend on the spouse, because now their income is limited, so the spouse is the one taking care of the home. The children are here. Who would they be dependent upon? The spouse. So can we then conclude that the children will depend on their biological parent, the spouse? Yes. So if the children are able to prove that, yes, whilst I'm here, the spouse of my step parent, so to speak, my own biological parent is the one meeting my needs. How do you show it? You got to show it through your bank statement, money given to you in the bank, even if, or money given to you for transportation, for this and that. It might be that they have taken mobile phone contract for you, they are paying for it. Yes, that's evidence. For the accommodation in terms of tenancy, evidence suggests that yes, tenancy shows that you live there with them and your name is maybe on the tenancy. Food the person buys for the home, of course, your name will not be on the receipt. Nobody's name will be on the
Obviously,
food
yeah.
receipt from the grocery shops. However, if it's for the home, then we conclude that he or he
contributed.
he or she benefit from that shopping
Okay.
that the parent has or often made. And so put all this together, and it's a matter of expressing it in the form of argument. The caseworker that this is the sponsor. The sponsor is at this stage not able to show dependency. However, for these reasons, however, the sponsor's wife or so to speak, let's say spouse is able to show. We conclude that the spouse is a dependent parent under Annex 1 of the provision.
Okay.
So we have established a dependent parent. Then we move on to say the dependent parent is the one meeting the needs of blah, 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 blah. And you provide your evidence. Because if you don't, they will always come back to say, show that you depend on your sponsor. That is where you have to point out to them that, well, even if I don't depend on my sponsor now, I depend on the sponsor's spouse.
Or the spouse. Okay, so it's a bit straightforward, but quite technical, and I would advise that you get the lawyers and the people with the technical know-how to do that for you. The question we have posed is my sponsor's spouse a dependent parent for the purpose of providing dependency in EUSS family permit applications? The answer is yes. And lawyer Charles Asma has graciously explained all the technicalities, the mappings, if you are interested in mathematics and all that, to get us to understand that, yes, your sponsor's partner could be seen as a dependent parent when you doing your EUSS family parent application. We're live here, and we will be activating the lines very soon. Your comments, your questions are invited now. The text number is 07950 422780, and you can call us on 0208 123 1016 or 0739920848. Text, as I said, 07950 422 780. If you have any other questions on the platform, we can pick them now. But lawyer, one question here, I think it's an audio. Let's see if we can pick that one up quickly. With your permission, please, let's start
Sure.
with that.
Hello, lawyers. Mabacho. Good evening. It's Mr. Framponi and I apply for settled status application that's all system at the moment. Na me oba odi be 6 months. Na me pese me de ne ka application ho. Na me apply for also settled status emano. Na me try say me application no edru baby ana mo say me register a identity check for the baby. Now, identity check now more requested either passport or biometric residence card. But me bano is just 6 months. Only passport, only biometric residence card. Your one in the birth certificate. Inti number say me who say about my 3 options. But use the EU exit ID document check app. And I can book an appointment to scan my identity document in person. And I will enter my document details online and send my identity document by post. But among these 3, which option should I use? And I say I was me use a different way. Now me apply, now me link about foreign application to mine to me application, and that's it.
Right. We answered this question last week. I quite remember. So I'm not going to go into much depth with my response. My response the last time was that if you make application, you make with your ID, passport.
Okay.
If the passport is expired, you tell them it's expired. Because when you are making that, you have to provide those details.
Right.
So once you have finished, especially in the EUSS, they will ask you to provide that ID you used. And when you are going to do your biometric, they ask to see the ID as well. This is a child who doesn't have an ID. And my conclusion was that if somebody doesn't have an ID, passport, and the application is requesting that, that means they must get one.
Right, get one. Yeah. Okay.
Yeah. So
Okay.
Otherwise, he can wait. When he gets his settled status, he registers the child.
Okay. Another one here. I think I suspect we might have looked at that, but let's bring it up once it's come up. Says I'm on 2.5, 10 years route, and I'll get 10 years next year. What will be the requirements for indefinite leave to remain? I think that came up as well. What will be the requirement?
So, what are the requirements for making an indefinite leave to remain application? You need to show that you have passed the English language test at least B1. You should also show that you have passed the life and language of UK. That's what we call the life in the UK test.
Okay.
Life and knowledge of the UK test. You must also show that you have lived in the UK. And of course, if the person has been living 10 years, they will have enough evidence to show that. Of course, you also have to show that you can pay for it. So these are some of the things the person would need. And of course, get the right form to make the application. And because this is indefinite leave to remain, there are a lot of permutations under that, depending on the route. Somebody will be making indefinite leave to remain based on the spousal route. Somebody will be making based on domestic violence route. Somebody will be making based on the standard route. And therefore, it depends on we have set O, set M, set DV, and what have you. So I would say that make sure that you know your position so that you can go for the right form. If you get a form wrong, the application is not valid.
Okay. There's a question here. It says that I have no recourse to public funds on my visa. I work with a charity that is prepared to put in a case for me. Would they succeed?
What case is the charity putting in?
Says there's no recourse to public funds on. So I'm
So
assuming that they put in a case for them to say that that should be taken off the person's visa.
I thought it's the person said, I have no recourse to public fund on my visa.
Yeah,
I have not.
I have.
I have.
Yeah.
Oh, right. Okay. Yes. So this is somebody who doesn't have money and cannot go private to do it. So has spoken to a charity organization that rely on legal aid to help those in need of such support. So those people can, yes, do it for our.
So what argument would they, how would they argue it out that the no recourse to public funds should be taken off the person's?
Well, would have been the same argument that a lawyer privately doing the application would have made, just as we do. So the question maybe would have been or should have been, how do I show that they have to remove my no recourse?
Okay.
Now, no recourse is case law, has a case law underpinning, and it became obvious during the COVID pandemic. So somewhere 2020, 3 children, RW and another, through their supporters, took the government to court to say that our parents cannot take care of us because they are not working,
Okay.
or they work but their income is limited. And some of them working because of COVID, they've been asked to stay home without any pay. However, they have restrictions on their leave and they cannot get support from the state. We are dying. So who is speaking? The child. So it focuses on the child as opposed to the parent. So what should the parent prove? Prove that what we have said so far is the case. That you either work or you work but not enough income to meet your essential living needs. And especially that of the children. And so without the intervention of the state, the children's welfare will be precarious. So once we argue the precariousness test or point, then the person will succeed that yes, if the state doesn't intervene to remove the condition so that the parent can access support for the children will be in danger.
Okay.
So that is how you prove it. And if you say you don't have money, prove that you don't have money. Pay slips and bank statements and all that.
Well, thank you. Another one here says, lawyer, I have default on my credit record. How can I get it removed as it is affecting me accessing a government scheme for accommodation?
So it is not a default per se. It is a county court judgment. It's called CCJ. Because if you have a default, it will be on your bank record, not the public record or the court's record. So that's the difference. So this one, the person has defaulted and has been taken to court, and a judgment is passed that they have to pay.
Okay.
And because of that, they are on the record for 6 years. How do I get it removed? You can get it removed within 28 days of the judgment. Within 28 days. Unless, of course, you have evidence to suggest that the application court, the claim for the payment of such default was made and you did not receive any acknowledgement from court, and the matter went to court without you, and therefore you've been disadvantaged. So there was no fairness or justice in this judgment. Then you'll be given the opportunity to argue your case for the matter to be opened again. That's the only way. Otherwise, once it goes, it goes. After 28 days, it stays for 6 years. The best you can do is to get it satisfied. Getting it satisfied means that you pay the money or the debt.
Okay.
Paying it doesn't absorb you anyway, because the judgment is that you are going to be punished for 6 years for defaulting. and
So,
still
so
not paying.
it means that when you have it satisfied and um, you send proof to the scheme that this person says is trying to take advantage of, you send that to them to say, I have satisfied the debt. So I qualify, even though it's going to stay on my records for 6 years. Can you make a good argument like
Well, it depends on what the scheme requires. If the scheme requires no CCJ, then satisfaction will not solve the problem.
that? You have to wait 6
If
years
the
for you.
scheme is CCJ but with exceptions, then if it's satisfied, the scheme might say that, okay, it's satisfied. The question will be, when was it satisfied? It will also be there when it was satisfied. Then, depending on the circumstance, the scheme administrators might say, that's fine. Once you've satisfied it, no problem. Yes, you still have your credit history dented, but no problem. So it's up to what the scheme wants. But to answer our colleague, can I get it removed? You can't get it removed if it's more than 26 days. Unless, of course, you want to argue strongly by making an application to court to have the judgment set aside.
Okay. Well, we have Nana Tufo online. Odisha Banana Kwekume, thank you very much. Darlington Smile, thank you for coming on board. Blessings in Sandra Fraser, Sandy, good afternoon. And we have Bua Naomi, Ricky A. Boche, and Yao Boachi Ajimai. You have all joined us. Thank you so very much. We're doing this courtesy BWF Solicitors 214-218 Tottenham High Road, Seven Sisters North London, London, N15 for NP. Via public transport, Victoria Line to Seven Sisters, use exit number 2, and that brings you to the frontage of Anna House. BWF Solicitors is on the 4th floor. They work Monday to Friday between 9:30 a.m. and 6 p.m. 0208-493-7340 is their number. The emergency one is 077-127-61884. Remember, with BWF Solicitors, we have a trusted partner when it comes to the law. Their message will be back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community,
is a member of the Family Law Panel
and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208-493-7340 or 077-127-61884. BWF Solicitors, your trusted legal partner.
Okay, we are back. Thank you very much for sticking and staying We get to the line, they are activated, so you can call in and get your question across to lawyer Charles Asma, who is our guest from BWF Solicitors, live on BW TV. 07399208 or 0208-123-1016. Hello, good evening.
Good evening. Uncle
Hello.
Kuku and Lord Charles. Hello.
Yes, sir.
Hello.
Good evening.
Good evening, Uncle Kuku and Lord Charles.
Good evening.
I just want to take your views on, your advice on this. So, you were talking earlier about wills and intestacy. Now, I know maybe most of the discussion is centered on the UK. It's an assumption I'm making. But in terms of Ghana, you would see situations where the family, I mean, the parents or the extended family of the deceased, seem to stake a claim in the estate of the deceased. Where does the law stand on that? And in instances where, for example, the deceased has a property which the family claims that the deceased, for example, built it jointly with the surviving spouse, and therefore they have a claim to it. Where does the law stand on that? That is number one. Number two is those of us in the United Kingdom who are maybe in the gig economy, who, for example, maybe do not have the right documentation to work. However, for purposes of employment or immigration, you want to use some of these processes to get by. Where do you stand in terms of if you have to, for example, provide documentation in terms of your taxes or filling tax forms and all that in the gig economy? Thank you very much.
Okay.
All right. So the first one is a jurisdictional matter, and I refer to the Intestate Succession Act of 1985, and that's a piece of legislation in Ghana, which looks at someone who, or if someone dies intestate, how will the estate be distributed? So the law is clear, and those who pursue it get their fair share. I'm also mindful to say that there are instances where people don't follow through the law and they try to box their way through to get what they want, thinking that they gave birth to their deceased child or family member, and therefore their property should be their property. Depend on the family involved. Some families are very decent, others are very, very different. But whatever is, where would those people stand where they are being intimidated to give up the properties left behind and all that? That is why the laws are there. If the person did not make a will, you just follow through what the government has proposed, the Intestate Succession Act or law. There are also instances where the person might have expressed or made certain statements to the family members that if this, when I'm gone, this should happen on my behalf. And that's why I use the word decent. Those decent families will follow through so that everything is peaceful. But where things are not peaceful, the person, the one who is aggrieved or being intimidated, should follow through the law, and the law is clear. If the person dies without a will, which law applies in Ghana? And it is the position. The second question was those in the gig economy, so looking at the ITs and all that, and also they may not have the right documentation, so the person is undocumented. How do they He talked that he wasn't clear, but he talked about.
He's still on.
Oh, fantastic. Hi, hello.
Hello. Yes.
Oh, hi, yes. So the second question, are you making reference to wills and probate, inheritance, administration of the estate, or you are making reference to documents in terms of making application to the Home Office?
Yeah. The second question is not connected to wills and probate as well. This is independent, so immigration, strictly immigration.
Oh, immigration. Right. Okay. Thank you so much. So, in terms of making application, how do you prove all the documents that you need? It depends on which application you are making. If you are making an application based on your private life, having lived in the UK for 20 years as an adult, or in terms of children, 18 to 25, or 10 years, the argument is so. So let's stick to the adult argument, private life. If you have lived in the UK for 20 years, if you are making an application, I think we have discussed this at length in the past. But all you need to show is evidence that you have been living in the UK. And it doesn't really matter. So long as your name is on the paper or document, and there's date and address to show that, yes, this is UK. 2, this is the date within that 20 years. And 3, this is the person we are talking about. That's all the person needs. Whether you were documented or undocumented, whether you had this or that, it doesn't matter. You are just saying that I was in the UK. So this could be official letters or records from GP, hospital, from council, from this, from that, even HMRC. There are people who use what we call provisional NI, TN with their date of birth and something at the bottom or end. Then eventually HMRC may write to them to say this or that if they have overpaid or underpaid tax. That is also a piece of evidence that you've been living in the UK. So if you put all this together, that will show or serve us. And if you were also schooling or undertaking a course, these are all part of your evidence. So that is to prove your 20 years. If you're making an application as a parent of a qualifying child, be it British child or EU child, in terms of a child with pre-settled or settled, then the argument we are making is that you just have to prove the relationship to the child and also the fact that you are the parent of that child. So the birth certificate of the child showing that your name is on as a father. You just have to also prove that the mother can show that you play a role in the life of the child, or GP can confirm that yes, you are part of the child's life, or school can show something. All these pieces put together, you make your application as a parent of a qualifying child, and that's direct access, whether mother or father, or male or female. And if you are making an application as a spouse, or as a parent of a stepchild, you do all this. So each application will call for specific evidence to provide. But it doesn't really matter whether you have your leave or you don't have your leave. You just need the right evidence to support your application. So I suppose that helps.
Thank you.
Okay.
Thank you
All right.
so
Thank
much.
you. Thank you for coming on, and thank you for your faith in the program. Thank you very much. Next one, we have there's a couple of voice notes. Let me quickly pick that one up. We have some comments on the platform we will be picking up very soon, but let's go to this one.
Good afternoon, Uncle Oreko. Any lawyer? Bichiamu. Bebre. Nyamenshamu. Any majuma paramo here at the boy in community. No. Now, pacho and as a mocha about landlord. Na be miss me rent it from private landlord. Na the problem roof eliki about both chimneys here in the bedroom. No. Na my company since 2020. Yeah, sorry, 2020. Almost send you about any year. About any I report. In this case, at the end of meeting me, but you'll be again check a card with me about me. Bye bye. Hello. Lawyer asthma any achlorotic. Yamisha money mapa. The patrol never pay me bisa say already a child a British or detainer. Yeah, a form T and then the friend is saying, oh, Ghana, oh, your form so Ghana passport. Oh, me at the Ashima, the patron and the same. And after so more, Sako biometric now. Requirement is a for ID brand na bisa but already start planning there. The name say be ID cry also the can. Ti pa chon put me a church no mu kakra. Ama me ho an dem ase. Bye bye.
Can you play that again? Because the beginning was not clear.
Yeah. Would you want to take the first one? Because I think it was sent by the same
Okay,
person.
all right. So the first one has to do with habitable accommodation or rented property. Some time ago, we delved into that, and there was also an update on that the landlord is required by law to ensure that the property is cared for properly. So there is a duty upon the landlord. Now, there should be, in addition to quiet enjoyment of that property, so that the landlord does not serve as a nuisance by always coming there, the place should also be habitable. And I remember we were looking at whose responsibility it is to make it habitable, depending on the nature. And this one, it appears that it will be the landlord's responsibility because she's making reference to the roof. So if it is the roof, then the landlord has to put it right.
Okay.
She says that the landlord is not willing to do anything about it because she's made incessant calls upon the landlord. If the landlord is not responding, then you have to report to the council.
Okay. All right. The second one, as you said, let me play that again.
Hello, good afternoon. Lawyer asthma any achlorotic. Yamisha money mapa. The patrol never pay me bisa say already start a child a British or detainer. Yeah, a form T and then the friend is saying, oh, Ghana, oh, your form so Ghana passport. Oh, me at the Ashima, the patron and the same. And after so more, Sako biometric now. Requirement is a for ID brand na but already start planning there. The name say be ID cry also the can. Ti pa chon put me a church no mu kakra. Ama me ho an dem ase. Bye bye.
All right. So with registration of children, remember, so this will help us to understand the earlier caller's point where he's made application, wants to include a child. The child has no passport or ID, but they're asking for ID and wanted to know which one to provide. And I said that if the child who is a foreign child doesn't have an ID, then it might be the case to find an alternative. Now, this time, remember I said that he could consider registering the child. So this is where we are registering the child. If the child, the question would be, what's the nationality of the child? So you point it out. At the time of registration, the child nationality depends on how the circumstance plays out. It will either be British by birth um, or the nationality of the parent. Especially if this registration is for registration private life, so you can see that as private life application. If it's private life application, the child has been in the UK for 10 years, and we are registering the child. Then the child has the nationality of the parent. But we are not going to the nationality. So what's the nationality of the child? You have selected whatever you select. Next question, do you have a passport? You answer yes or no. If you say yes, you provide the passport details. If it's expired, they will ask you to provide the details of the expired passport. If you say no, they will ask you why. It might be that a child has not had any passport. That will be your response. So it depends on the answer to the question and just follow through.
Follow through. Okay. Well, let's pick up this voice note before we go to the comments. Please bear with me. Let's pick this one up.
Good evening, Lawyer Charles Brero. Me patrol, na me fie bi mu 1 month ago, and me too. Even me the advice craft free lawyer ho. Na me awie no me free me contract no 24 February. And omo di mpa foforo ba afie mu on the 25th of February. Afi eno omo de press bi abrɛ me sɛ me makɔso saa damages no nti na ɛwɔ sɛ metua ebi ne sɛ carpet ɔmo atwa carpet walls no ho amakemake bulbs a ɛwɔ fie hɔ sales awu ɛna roof ceiling a adamage a ɛyɛ leakage a na ɛleak from roofing no ɛna ɛma ceiling no ɛsɛe me make several complaints a ɔmo anyɛ mefiri hɔ na afei deɛ ɔmo aba abɛyɛ ɔmo sɛ that cost ɛyɛ me meka pɛ sɛ mbisa lawyer sɛ ɛyɛ possible saa na ɛde advice nso na metumi anya because nyɛ me mekɔ so saa roofing even mold black mold kora ɛbɛ dan no kora ɔmo sɛ ɔmo atutu black mold no na ɛno nso yɛ me meka.
Lord, this person has sent a video of the damage she's talking about. It doesn't show any identity, so I would want to put it on whilst we try to answer that question. This is the damage the person is talking about. That's the roof that was leaking when she was living there, and she says that they've sent her a bill to pay for this. But if it's the roof, obviously, she doesn't have to pay, does she?
Yeah, so we have to apportion the duty. You can see that it's one of the duties that will go to the landlord.
Right.
And I'm sure, as the lady pointed out, pursued the landlord to do the right thing. Landlord refused. Now, I was trying to get the dates when she said she left and the other person, but it doesn't really matter, depending on the nature of the damage or whatever we are looking at. The date she left and somebody took occupation of the property wouldn't really matter. But if it's to do with roof, whether she was living there or she's left, it is the landlord's duty. If it's to do with mold, who treats the mold? It's the landlord.
Yeah.
Because all you do is live in the property. You don't create it. The mold is created as a result of the structure, the weak structure or the nature of the soil. So if it's not being treated properly or carefully, then it will seep and get to other parts of the property. So eventually, we know that the landlord is responsible. So if these are the things that she's referring to, then I would say it's the landlord's duty
To repair
to repair, and the landlord has repaired them. The landlord cannot ask her to pay.
I'm suspecting that her deposit is at risk now.
So the deposit is at risk for reasonable damages. And of course, those damages, let's say there was the paint, there have been a lot of marks on the wall and all that, and the landlord had to repaint. Then we're questioning ourselves, who caused those marks? Is the tenant. If the floor is damaged, then it's likely it might have been caused by the tenant. The tenant. So in terms of the marks on the wall, the tenant. In terms of the floor which is damaged, tenant. But things like the structure of the property, the roof, the molds and all that, that will not go to the tenant. And again, maybe the garden has been left for the weed to overgrow, and there have been rodent infestation and all that. And of course, the tenant living there should have taken steps to ensure that this is done properly. Then the landlord can say that maybe because of what you left this to be, I'm going to clear it, but you pay for. Those ones are reasonable.
So there should be some reasonable conversation between the landlord and the tenant.
So yes, the deposit is at risk, unless of course we don't have all the information. We've seen the image.
So one interesting scenario. You live in somebody's property, which is carpeted, for instance, and obviously after a long period of usage, it will show some wear and tear. If you are leaving, the tenant, do you have to change the carpet?
That's a good point. So there are also instances where the carpet may not necessarily experience extreme wear and tear depending on who was living or is living in the property.
Right.
It's obvious or it's possible. And therefore, if it is possible that we want to open the conversation up to check whether this carpet is changing its nature as a result of normal wear and tear or as a result of contributory negligence by the tenant. If it is the negligence of the tenant, then the landlord will say, I'm going to change it for the new person, but you've got to pay for it. So it depends on what we are talking about, and it to be obvious.
Okay. All right. Let's pick up the comment on the platform, and we continue on that. Hello, I've been granted 30 months, 2.5 years leave to remain on the 10-year partner route under paragraph D LTRP 1.2 of Appendix FM. The permit would expire in December 2023 and is subject for renewal. My partner and my kids recently attained their indefinite leave to remain status. Please, I would like to know if one, I can switch my route and which, and two, how soon can I make application on any of your proposed bet or option and the total cost, including solicitor fee. Kuya Pokuche.
All right. So our sister was granted or has been granted another 10-year route, I suppose.
Yeah, 30 months, 2.5 years on the 10-year partner route.
Yes, yes. So 10, good. Yeah, I saw 10, so yeah, it's there. So 10-year partner route. When it comes to partner, even when you switch, you'll be put back on the 10-year route. That's the position Home Office has taken. Otherwise, it will be easy for everybody to claim to be a partner and yet want to go on the 5-year route. So they've been very careful not to open the floodgate. Well, if our sister Ekia is no longer living with a partner, then she can take steps to switch. In this case, she will be making the application, of course, as a parent, with direct access, possibly to her child.
Okay.
And of course, how soon? How soon is always the case that you make application 28 days, within 28 days to the expiry of that visa or leave. So if your visa is expiring today, then 28 days before today, you could have started your application. So the last day or count 28 days back. Depending on your situation, you can even make it earlier. Option total cost solicitor fee. There are two options. You go for priority, which is £3,400, and that can be decided within 1 week after you have done your biometric, or even the same day, depending on when it's picked up. In addition to the solicitor's fee. How much is the solicitor's fee depending on who the solicitor is, and therefore I'm not able to give solicitor's fees because I don't know all the fees of all solicitors. So that's the point. So depending on who you approach for consultation, they will share their fee structure with you for such application. If you go for the standard application, it's £2,608, and that includes the IHS. So those are the two fee structures. The priority fee structure, 3,400, and the standard fee structure, 2,608.
Okay. Your text, your comments, 07950422780. At this time, I'm going to give the next 3 minutes because we have to do a quiz. I'm going to give the next 3 minutes to my dear colleague, Na Mayete. Na, good afternoon.
Good afternoon, Kweku. Good afternoon.
How are you, boss?
I'm good, and you?
Well, we are alive and kicking. Okay,
Thank
now, quick one. I think we're running out of time. So,
you.
any outstanding questions or anyone that you have in your phone? Let's hear you.
Well, actually, I've got a couple of questions, but I'm not going to do that now. I will rather postpone them to next week when we
Well,
can. But
somebody was asking me to wear kente, and I believe you have done it very well for me.
oh dear, that's good.
But I've got mine here, so it's fine.
Oh, beautiful. Okay, so straight to the point. Just
Yes.
I only pop in to make a few advertisement. That is just to let the public know, or the community and the law, our viewers and our listeners, our lawyer favorite family. And I've got some course. I've got some two companies that are recruiting ASAP, and they contacted me yesterday. So if anyone is interested, the person can straight on contact Katie Ed Consult, and we're happy to help the person through this recruitment. So that's all. And then secondly, the teaching, the come to teach in the UK thing is also in progress. So if you are interested, you know someone who is a teacher in Ghana and want to come and teach in the UK, the in and out of it, how to get here, get a school, is also in progress. So if you are interested, just pick up the leaflet. And there is a consultation fee, though I must confess that. So when you come in and you want all this information, we'll give it to you and we guide you one-on-one until you step in the UK to start your teaching. So that's all I want to say, since we have just limited time to do our quiz, Kweku. Thank you very much.
Well, thank you very much now for the piece of information, and I believe that if you are interested in that, get in touch with KT Education Consult. You can send an email to kt.edconsult@gmail.com, kt.edconsult@gmail.com. Yesterday, I think there was scheduled for a Zoom meeting to just orientate people as to how to get involved with the teaching in the UK. Pick up the numbers 075966200154 or 079617646662. Details on the left hand side of your screen, and you will be able to have all the information you need so you can enroll. Katie Ed Consult is giving you the opportunity to do that. So prepare with the experts and pass with the experts and get your satisfaction. Thank you very much. Let's quickly go on to our quiz. And we have a question on. Okay, now Katie and Abraham have been in a relationship for 20 years but unmarried. Abraham had two children from his previous relationship who are both successful lawyers and estranged from their father. They have not spoken to him for 15 years. Abraham died in a fatal accident, unfortunately, in 2022. He leaves behind an estate worth £3 million. He did not leave a will. Remember in the nuggets, we said somebody who died without a will died intestate. Okay, so there, at the definition, intestacy occurs when a person dies without leaving a valid will and is said to die intestate as opposed to testate. Where there's no surviving spouse, the children of the deceased receive the estate. This includes legitimate, illegitimate, and legitimated children, as well as children adopted by the deceased. Even if the deceased made a will, there are circumstances where some the estate may fall into interstacy. Okay, now let's go back to the quiz. And the question I am bringing in is this. Kathy will inherit. Okay, explain who is likely to inherit his estate. Now, Katie or Kathy, however you want to pronounce it, and Abraham have been in a relationship for 20 years, but were not married. Abraham had two children from his previous relationship who are both successful lawyers and estranged from their father. They have not spoken to him for 15 years. Abraham died in a fatal accident in 2022, which is last year, and he leaves behind an estate worth £3 million. He did not leave a will. Explain who is likely to inherit his estate. Kathy will inherit him because they have been together for 20 years and his children do not speak to him. Two, the state will inherit all the estate because he did not leave a will. Three, two children will inherit him because he did not leave a will. So let's see what answers you can bring in. So before we even hand it over to a lawyer to explain what the correct one is from the three scenarios we have. Kathy will inherit him because they have been together for 20 years and his children do not speak to him. Two, the state will inherit all the estate because he did not leave a will. And three, his children, the two of them, will inherit him because he did not leave a will. So let's see what you have. Put your comments and your text on the platform, or you can send it via text 07950422-780. Kathy and Abraham have been in a relationship for 20 years but are married. Abraham, two children from previous relationship who are both successful lawyers and estranged from their father. They do not speak to him, and they have not done that for 15 years. Emmanuel Sechi, sorry, says number three. Number three says his two children will inherit him because he did not leave a will. What do you also think? Let's hear you. Let's see what you have. Who else? One, Kaifi will inherit him because they have been together for 20 years and his children do not speak to him. Two, the state will inherit all the estate because he did not have a will or did not leave a will. Achilles Baraza. Okay, let me pick that one for you. Achilles Baraza, he says number three. Achilles number three, which is his two children will inherit him because he did not leave a will. That's one on the text message platform. Naomi, yes, I've seen all your videos. Thank you very much. I think as the lawyer explained, definitely you have to have that conversation because certain things are not your fault. If the roof is leaking, other bits of damage which are not your fault, then obviously you have to have that conversation. Well, she's saying that when they had sent her the bill for her to pay, she went in there and no repair has been done. So she thinks that is quite unfair.
Yeah, well, I think there's more to it than just.
It meets the eye. Okay. Well, well. Time and tide as it waits for no man. We just got about a minute more to round up things. So I will go to lawyer and find out what. Okay, now what do you think would be your answer? I'll put you on the spot. Huh?
Sorry, it was muted before. Looking at the nuggets and then with the question that you've asked, I'll go for number two. The state will inherit all the estate because he did not leave a will. So
okay. So now we'll go for number two. Tilly Duma, I can see your number three. His two children will inherit him because he did not leave a will. Is there another one? Yes. Yao Boachi Ajimai, number one. Kathy will inherit him because they have been together for 20 years and his children do not speak to him. Lawyer, I've got three different answers.
So let's unpack the scenario.
Okay.
So Kathy, Abraham, the children, we don't know their names. Kathy and Abraham,
two successful lawyers.
Yes, so
that makes it
it's not even where they've gotten to in life, but the circumstance surrounding their relationship with their father.
Okay.
So Kathy, we know that was never married to Abraham, and the law looks to the spouse. Therefore, Kathy it has no share in the inheritance or the property.
Okay.
So she's out. So who is left? We move to the children. Now the reason is that the man did not leave any will. Abraham died without a will, and because of that, the intestate law will distribute the property first off the spouse and children thereof. There's no spouse, so spouse is out. 2 children, but we are told that their relationship with their father has become very, very sad. The word used there is estranged. And because they are estranged from their father, it appears though that relationship is broken, and therefore there's no link to them, between them and their father. So to speak, the Lord does not see them as children.
But if they can prove that they are legitimate children of it.
We are looking at, it says the relationship is broken. They don't talk to the man, or they were never talking to the man, the father. The father did not. Let's say that they were disowned, but it doesn't say this. It says the relationship is, it says they become estranged from their father. And if they become estranged from their father, then, so to speak, there's no relationship. The father doesn't see them as children, and the children don't see or didn't see him as the father.
Okay.
So we can see here that there's no child
Involved.
to place, to lay hand on, even though there is, but the circumstance suggests that it's difficult to. And therefore, there's no Kathy, there's no children, so the only one we have is the state.
So that makes it number. But one will push the argument that these children are enlightened. Even though they are estranged from their father, they may come in to say that this is my legitimate father. I have evidence to prove that the deceased is my father. Would the law look at them?
So that's a different conversation. But I think at this stage, suffice to say that we can't see a child clearly. So we conclude that there's nobody, so the state will place hold on the estate. Then we move on to the second part to say that what if they come back to say that we resolved our differences before he died? Does that make us okay? Maybe, but that is a different conversation.
And I remember the very first caller that came in with a question that you said is a matter of jurisdiction. In the African setting, the extended family will come in because probably the deceased might have mentioned to 1 or 2 members of his family that have these children somewhere. Even though they are very stubborn children, so to speak, they are my children. And once he dies intestate, the family would push these children to come forward.
But you also acknowledge that we have not discussed the Intestate Succession Act of 1985 on the platform yet here.
Okay.
And therefore, we cannot identify the provisions.
Okay.
And because of that, we cannot incorporate the presumption you are making that what if there are children lying somewhere, can they come in? We have to check what the law says with respect to the Ghanaian intestacy law. Then we can conclude on that point.
Well, so from what lawyer said to us, from the explanation, the only person that got it is Na Mayeti. Na?
Hello.
Somebody has just commented on the platform. Yabuachi Ajima says, congratulations, Na Mayeti. You are indeed a great teacher.
Oh, thank you, Iyawachi Ajimai. Well, so Oreku, what can I say? It's just we thank God for everything. It's another successful week, and Katie, we are doing wonderful things. So if you are interested, all you need to do is just WhatsApp me on the number or send an email and you get to me. If you call sometimes during the day and I'm not able to respond to you, don't worry. I will soon or very soon get back to you after I get less busy. So yes, Uriku, let me end here. Please, those of you interested in working in the care sector, as I've got 2 solid companies. In fact, I was shocked when I had a conversation with them and the profile that they showed to me. So if you are interested to come and work, there is work available for you. Just contact me and then we make a deal on that. Thank you, Oreku.
Well, thank you very much. And with that, I hand you over to Lawyer Charles Asma for him to do the traditional thank yous and goodbye.
So, viewers and listeners, once again, we asked ourselves a simple question whether the spouse of a relevant EA national sponsor of EU family permit application is a dependent parent. We concluded that under Annex 1 of Appendix E provision, the person is a dependent parent. What does that mean? It means that such a person can stand in to prove that the child depend on him or her, and therefore the child depend on the parent, regardless of whether the main sponsor is able to show or not. Because the law says either the main sponsor or their spouse. So this is to let us know that it is not all doom and gloom, because when it gets tough, there is always a way, because the law says all, and so the all can be relied upon. Thank you for being with us this wonderful Saturday for this engagement. We believe that you join us once again. Wish you all the best, and shalom.
Well, with that, we want to say thank you for your time. Thank you for being with us. And thank you for staying. Your comments, your concerns, and your sharing as well has contributed to the success of this program. Thank you to Nama IT for coming on board to help us understand the situation with the teachers and of care route, and also answering the question so correctly. She was the only person that got it right. The technicalities and the rest of it, she was able to see through it. And also thank you to my studio producer and director, Professor Ade. Thank you to Padmo Dudu for the aesthetics and the graphics. And thank you to BWF solicitors, all the lawyers in-house and the admin staff. And we will be with you again same time next week. Until then, please be good. Have a wonderful week. And remember, on the 10th of April, 2023, we'll be having a barbecue and, of course, the legal clinic at ICGC King's Temple, Frederick Bremer School, Siddeley Road, Walthamstow, London E17 4EY. There will be free legal consultation. There's a lot of meat to chew on. There's a lot of hand-picked food to nibble on, a lot to drink, fun games, and of course, free legal consultation, as I said earlier on. So make a date, don't be late. To Sheila Ankra, my admin, thank you very much, Mrs., for all the support and the help. And to everybody, I say, have a good evening. God bless.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, oh, oh. Oh, oh, oh. Everybody say